Yeah, so good afternoon, ladies and gentlemen, and welcome to another episode of my lecture. On today's episode, we are talking about implied terms. My last class, I talked about terms of the contract, and I introduced you to what terms of a contract is. If I can remember, we talked about not just terms, we talked about mere representation. That was the first class. We talked about the difference between a term of a contract and mere representation. And in our second class, we talked about conditions and warranties. Those are terms of contract. And then in our third class, we talked about innominate. So yes, as I was saying, so I hope that you've watched those classes. Sorry for the break in transmission. I hope that you've watched those classes before this particular class, because those classes are supposed to give you a better understanding of what we mean when we say terms of a contract. Do you understand? So you need to know what are conditions and warranties. You need to know what are innominate or intermediate term. You need to know what is a fundamental term. You need to know the difference between a term and a mere representation. But in this class, we are talking about implied terms. Now, what we were talking about previously were express terms. When express term of the parties, when parties expressly tell each other this thing or that thing, for example, which one will be a condition in what they've told each other, which one will be a warranty in what they've told each other, and stuff like that. But today we are talking about implied terms. So let me put it as our topic for today: implied terms. This is what we are talking about today, implied terms. Now, before I start the lecture, standing before you, for those who don't know me, is Olayeni Dear Kolola Daniels, popularly known as Dear Call Spectre, and welcome to another episode of Dear Call Talks Law. And on today's episode, like I said earlier, we are talking about implied terms. Now, before we go to our note, or let me just go straight to the note on implied terms so that we can be as fast as possible. So all contracts are concluded within the context and framework of established practices in the commercial, social, and economic culture of society. These practices therefore constitute an accepted and recognized part of a contract to which they are relevant without a formal and express declaration by the parties to that effect. Furthermore, these usages have been supplemented for reasons of public policy and the promotion of commerce by statutes. Apart from the above, courts have frequently found it necessary in construing the terms of a contract to assume the existence of certain terms not expressly included by the terms to the contract in order to give it what is popularly referred to as business efficacy, that is, to make it capable of being performed effectively. The net effect of this phenomena is a recognition of three types of implied terms: implied terms by trade or custom, implied terms by statute, and implied terms by the court. Now, the whole grammar of what we are saying, let us come to a better understanding of it. The whole grammar of what we are saying. Let me give an example for you to understand what I'm talking about. Now, imagine that a boy and a girl, they want to go into a relationship. So the boy sees the girl, and then the boy goes to meet the girl and tell the girl that she looks beautiful, the most beautiful person that he knows, and those things like that. And then the girl, girls are always like, oh, and stuff like that, and they are, blushing and all that. Now, the point is, as at the time the boy goes to meet the girl, And let us say they went out on a date and then they are discussing, and then the girl then agrees to date the boy. I need you to understand something. When they are talking, there are certain terms that they would have, told each other. For example, I like this, I like that, all those, I like this, I like that, this is a turn off for me, that's a turn off for me. But they cannot envisage every possible consequence of a relationship. Do you understand? While they are having that discussion, and there is offer, will you be my girlfriend? And the girl says, yes, I'll be your girlfriend. Right? There's offer, there's acceptance, and all those things. While they've made a contract, that's a relationship, so to say, they cannot envisage, rather, or every possible thing to tell each other. Do you understand? However, there are some things that will be termed to be implied into a relationship. There are some things that will be said to be implied into a relationship. One of those things which should be implied, which they do not expressly need to tell themselves, are you listening, is the fact that there has to be loyalty and one party should not cheat on the other party. I don't think that in a relationship, when a relationship is starting, it has to be expressly stated that, oh, you cannot cheat on me. You cannot go out with another guy, or you cannot go out with another girl. Do you understand? Parties don't need to tell themselves that. It is implied. Do you understand? It is something that it is the essence of the relationship. The reason why you guys are being exclusive is because you don't want the other party to then have any other thing to do with another party. Do you understand? But you don't need to expressly say it. Although you can expressly say it. But when it is not expressly said and the other party then decides to go and have an affair with someone else, can you then say that the other party who went to have an affair with someone else now say, but we didn't agree on that issue now. We did not say that, I'm not going to have anything to do with them. We didn't say that. What you asked me is, will I be your girlfriend or boyfriend? And you told me things that you like. You said you like coffee in the morning. You said you don't like this one. Do you understand? We did not talk as to specifically the exclusivity of each other. Do you understand? Just to ourselves alone. Do you understand? But then, is there a problem? Yeah, but then even when it is not spoken, common sense will tell you that except it was stated in a relationship that there is no exclusivity, where it has not been stated that there is exclusivity, it is implied that there is exclusivity amongst parties. Do you understand? So another component of a relationship could be honesty and loyalty. Don't lie to each other. If you are going somewhere, tell the person that you are going somewhere. Those kind of things. Is it first day that you people are talking, or let's say the first 3, you now be saying, this you must, like, you have a standard contract or something, you tell the other party to sign. So part of the clause of the standard contract, there is exclusivity. Don't go and, do you understand? You must not do this. You must not do that for every single thing. It's not possible. So therefore, there are certain things that are implied into the relationship. The same thing goes for contractual relationship. When two people are doing buying and selling, there is only a little as to what they can say. Certain things are implied into their contractual relationship. For example, if I want to buy a phone in the market, for example, and then I tell them I want to buy a phone, an iPhone and all that, it's when you are buying a phone, what is the purpose of buying a phone? Is it not to make call, to text and all that? Now imagine that I buy a phone and then I cannot call, I can't text, it doesn't use internet, it doesn't use Wi-Fi. The only thing I can use is calculator and play game. Do you understand? And then I want to return the phone, and then the guy asked me, what did you say you want to buy? Phone, Abi? Phone. Very good. What is that in your hand? Phone, Abi? Phone. Very good. That's the end. But the phone I wanted to buy is for the purpose of calling, for the purpose of texting, for the purpose of communicating. This phone is not fit for the purpose of what I want to use it for. So, although we had not expressly told each other, but I mean, just like you want to buy clothes in the market. What do I want to use clothes? Do I want to eat clothes? Is it not to wear clothes? So imagine I buy a cloth and then after wearing it, I start having rashes on my body. and then I now go to return it to him that this is your clothes, there's a chemical there that is giving me rashes, please take your clothes back and give me my money. And the person said, what do you want to buy? Clothes, abi? Clothes, very good. What is in your hand? Clothes, abi? Clothes, very good. So why exactly are you returning it? It is not fit for the purpose. He's not telling me that the other party, that's the seller of the clothes, he's not telling me that, but you not tell me say you won't wear them. So if I don't want to wear the clothes, what do I want to do with them? Do you understand? What do I want to do with the clothes? Do I want to eat the clothes? Do you get? So what is the purpose for buying the clothes? Was to wear it. Did I necessarily need to tell the other party that I am buying the clothes to wear it? No, I don't. But there is an implied term that that clothes must be fit for the purpose of wearing. Do you understand? So these are the issues that we'll be considering when we are looking at implied terms. So we have three implied terms: implied term by trade or custom, implied term by the courts, and implied term by statute. The one we are talking about today is implied term by trade or custom. The next one we'll be talking about is going to be implied term by statute, and the last one will be implied term by the court. Do you understand? So at least I hope I've given you an insight on what implied terms are. You don't need to have a definition, you just need to understand how it works. You know, there are two broad types of term: implied term and express terms. Express terms are those terms that have been said between the parties, right? While implied terms, they have not been contemplated between the parties, but because of the trade and custom in relation to that transaction, what people usually do in relation to that transaction, it is implied that the both parties have contemplated it, even if they had not spoken about it, they have not expressed it to themselves. So implied term by statute, there has been a law made that if where parties have not told each other these things in a contract, because this law is in operation, what is the name of that law? The Statute of Goods Act. Because the Statute of Goods Act is in operation, the conditions from section 12, section 13, section 14. Now, the conditions in this section which talks about implied terms would be implied into your transaction, even though you have not said it to each other. Do you understand? But it is implied into your transaction that you want it to operate. If you know you don't want it to operate in your transaction, you have to put a clause there that you are excluding any implied term. We'll talk about that when we get there. And then we also have implied term by the court, where the court will imply terms into the contract that has not been expressly stated by the parties. So with that explanation, we can then go to our first thing for today, which is terms implied by custom or trade. So let's go to the class where we are talking about terms implied by custom or trade. How many minutes now? 13. Okay, good. Now, terms implied by custom or trade. A contract is subject to terms that are sanctioned by custom, commercial or otherwise, although such terms have not been expressly mentioned in the contract. This principle and its mode of This principle and its mode of application were clearly spelled out by Part B in Houghton versus Warren. Houghton is spelled Hutton versus Warren Warren. What did Part B say in Houghton versus Warren? He said that as it is long been settled that in commercial transactions, extrinsic evidence of custom and usage is admissible to annex incidents to written contracts in matters with respect to which they are silent. The same rule has been applied to contracts in other transactions of life in which known usages have been established and prevail, and this has been done upon the principle of presumption that in such transactions the parties did not mean to express in writing the whole of the contract by which they intended to be bound, but to contract with reference to those known usage. So according to what Part B is saying, Part B is telling us that you cannot envisage every possible term to be put into a contract, right? You can't envisage every possible term to be put into a contract. Going back to the analogy of the relationship that I gave earlier, when you go to meet somebody, while you are talking to the person, will you envisage that, let's say as the girl, will you envisage that the guy beats women, or will you envisage that the guy gets angry irrationally and acts anyhow? No. Because you are meeting him for the first time, there are other preliminaries to discuss. But when it comes to beating, there is an implied term that the guy is not supposed to beat the girl in the relationship, right? There is an implied term that even if he gets angry, he shouldn't get angry irrationally to destroy the girl's phone or the girl's properties and stuff like that. So those are implied terms, in a relationship, although it's not respected by the court. I'm just telling you that so I can give you like an overview of how it operates. Do you understand? Of how implied terms operate. So in a commercial transaction, you don't expect that all the possible terms, all of them would be envisaged. Why two people, especially two, let me not say illiterates, but two people who are just business people, that are more focused on business. So somebody wants to buy something and it's like, one day I want to buy this thing from so and so. Does he have time to sit down and be envisaging all the possible all the possible terms that you put into the transaction? Do you know how many contracts he has per day? So, because you can't keep doing that over every transaction, the court would then imply the terms. That's what Part B is saying. He's telling us that, because we cannot envisage everything, and this particular customs, this particular term is known to customs and trade. You know that the first one that we are talking about is implied term by custom and trade. It is known. It is so notorious. Is a notorious term known to this particular custom, known to this particular trade, even if the parties had not stated it in that trade when they were having their contract. The court will imply its applicability. Do you understand? So let's go to another case. The first case that we cited is the case of Houghton and Warren versus R. Let's go to another case, and that's the case of British Crane Hire Corporation versus Ipswich Plant Hire Limited. British Crane Hire Corporation versus Ipswich Plant Hire Limited. Now, the plaintiff and the defendant were both in the business of hiring out heavy earth moving equipment. Now, when you say heavy earth moving equipment, like maybe tractors, all those big, when you want to demolish a house or you want to pull something that is heavy. So all those heavy earth moving equipment. The defendants, who were then engaging drainage work arranged by telephone for a drag line crane from the plaintiff. Now you should know that both of them, they are into the business of renting it out. They have the equipment, but I think that this particular equipment, maybe the plaintiff had already rented his own out, and then went to meet the defendants that, I think I've rented mine out, and so there's a pending contract. Do you have a free one that you can give me? I want to use it. They wanted to use it for something. And then the defendants who were, so it was the defendant who, called the plaintiff and told the plaintiff that they wanted to use the plaintiff own. That means they wanted to, borrow, so to say, or hire. Don't let me say borrow. Let me say hire the plaintiff's equipment. They were into the business. That means they had the equipment, but they must have given their own equipment out. Do you understand? And then they had a job to do, and that, I think that's a drainage work. So they had drainage work to do, and they needed the equipment, but they couldn't go and meet the other party who they already rented their equipment to, because there's a subsisting contract. So they then want to collect the equipment from somebody to use it, and that person is the plaintiff. So they called the plaintiff agreed. Now, although the fee was agreed to be paid, nothing was said about the condition of hire. Okay, the plaintiff, in accordance with the usual practice, sent a printed form of the agreement to the defendants for signature. So, although the fees had been agreed, this is the price, but anything about the term, they did not say anything about terms. Just said, how much are you going to rent it to me? We'll rent it to you for, let's say, 10,000 naira per day. Send it to me tomorrow, and then they cut the phone. Do you understand? You can see that all they agreed on was what? Was on price. There was no other thing that was agreed on. Okay, so let's move on. Now, the plaintiff, in accordance with the usual practice, sent a form of agreement to the defendant for signature, but before it was signed, the crane, without anyone's fault, sank in the marshy ground. So they sent the crane to them, that's the defendant, and then they sent a what was the word, printed form of an agreement where the terms are contained. Now they've not signed any agreement, which means they've not agreed on the terms. What they agreed was on the price, right? But before the defendant could do anything, what happened? The crane sank for whatever reason. Do you understand? It went into the ground, which means it will become destroyed. Now under the conditions in the printed but unsigned form, which was similar to those used by all the firms in the crane hiring business, including the defendants. Now, inside that particular document that they wanted to give them to sign, they had not signed it, so there is no agreement. You cannot sue them on an unsigned document by the other party. That's rule of contract, right? So, but under that agreement, there was something there. There was a clause which is so rigorous, so notorious, that everybody in that crane business, they know of this clause. Do you understand? It is everybody know of this clause in the crane business. And don't forget that the defendant is also in the crane business. The party that received the paper but did not sign, right, is also in the crane business. So what did he want to do? What did the clause say rather? The clause said that hirers are liable to indemnified owners against liability in the sort of situation which has occurred. Can you see? Now, I need you to understand what is done. We have express terms. The term was expressly stated in the notes, right, that hirers would be what? Liable, right? But because that term, the express term, has not been signed, the other party, that is vendors, now said, well, what did we agree on? Price. Thank you. Did I agree on that term with you? And the other party would obviously say no. However, this term that we are relying on is such that it is implied by custom and trade. The term is such that it is so notorious, everybody knows the term. It's just like you want to gain admission into a university. Do you understand? Without anybody telling you, you must write WAEC. So, first of all, when you hear that somebody is a university student, the thing that comes into your head is that person must have written WAEC. It is not necessary that the person had written JAM, because you can enter the university through other means. But the primary thing is that you must have O level. Now, I want to show you how notorious knowledge work. It is so notorious to any university student. In short, you don't even need to be a student. To anybody, that fact is so notorious to anybody that as far as you are a university student, you must have had O-level result. You cannot be a university student except you had O-level results. You can see how that fact is very notorious in your head, right? Now, put it in this situation. Everybody knows that when it comes to contract of hiring crane, right, the hirer is going to be a liability, especially in this situation. Yes, it has been written in the form of agreement that was sent to the other party. Yes, it was written express, but because it wasn't signed does not mean that the court cannot imply it, because it is such of an implied term by trade or custom. Do you understand that? So the defendant, however, resisted the incorporation of this term into the contract. They said no. They gave us a document, we did not sign it. By the time the thing got destroyed, right? So if it had gotten destroyed and we did not sign it, you cannot. Do you understand? Neither can you sue me on a document that I did not sign. But the court, what did the Court of Appeal say? The Court of Appeal unanimously held that the term had been incorporated. Both parties were in, and the defendant knew that firms in the plant hiring trade always imposed such conditions in regard to hiring of plants. Can you see that? Because they were in the trade, they knew that term, that implied term, was notorious. Everybody in the trade knows that this is the standard. It's just like if you want to go and get loan from bank, for example. It is the trade that the bank will not just give you, say, want to get loan, and bank will just sign loan of 10 million naira without you dropping collateral. It is the trade of the bank to drop collateral. That's a notorious fact for everybody. Everybody knows that. Do you understand? It is the trade that if you are going to the bank, you must drop collateral, which has to be something of is that wrong? Which has to be something of value as much as, if not more than, the money that you are collecting, because they are also going to add the depreciating value, you know, because in the next 5 years what you are dropping is likely to depreciate. So if you are bringing a car, do you understand what I'm saying? Except if you are bringing a land that is likely to appreciate in value ahead. So it is a notorious fact. So if you are in the banking industry, in the banking business, and then something happens and they say, since I've not, it is notorious. It will be implied into your contract. So in this case, yes, you had not signed it that hirers will be liable and then will indemnify the other party. Yes, you have not signed it, but it is a notorious fact in this business that it is implied into the business. Do you understand that? And that was held by British Crane Hire Corporation. British Crane Hire Corporation versus Ipswich, IPSWICH Plant Hire Limited. And then we continue with our note. From what has been stated so far, it is clear that the custom is impliedly, it is clear that the custom is implied only when it has been expressly or impliedly excluded by the contract, and where the usage is only where it has not been expressly or impliedly excluded. Now, this is another rule that we are talking about. You know, the first rule is that we can have where the parties did not mention or envisage a term expressly in their contract. The court can imply the term by trade or that's the implied term by trade or custom into the contract, right? That was what we said. That's the first rule, and we have talked about the authorities for that. Now, our second rule is where the parties have not excluded. This rule, the first rule, we operate where the party have not excluded the operation of that implied term or have not already stated what they want. Do you understand? So, for example, if there is a business and that business we pay every 7 days, is the custom of everybody in the business to pay every 7 days. But when I wanted to enter into the business, I made a contract to the person I was having the business with, and I told the person, expressly stated, I want my payment every 3 days. Now, as to payment, there is an implied term that you are to pay every 7 days, but I already have made it express in my contract that I want my payment every 3 days. Where the term has been expressly stated, implied term will not operate. Do you understand? Where the term has been expressly stated in the contract, implied term will not operate. Implied term will only operate where that term has not been expressly stated, or where the term has not been expressly stated. In fact, where the term has been expressly excluded, the implied term will not operate. Do you understand? So let me continue with the notes. So from what has been stated so far, it is clear that the custom is implied only when it has not been expressly or implicitly excluded by the contract, and where the usage is well established and notorious. Two things: when it has not been excluded by the contract, explicitly or expressly excluded by the contract. That's number one. And number two, where the usage is is well established and notorious, that both parties to the contract are either familiar with it or must be presumed to be familiar with it. The fact must be must be so notorious or well established that it is said that the parties should have been familiar with it. Either they are familiar with it or we are presuming that they are familiar with it. Do you understand that? So those are the two things when you are looking at a implied term by trade or custom. The first one that you want to look at, very importantly, the first one, has the parties mentioned anything about this trade or has the party mentioned anything about this term? If the parties have mentioned something, so pay me in 3 days, even if the custom is pay in 7 days, because they have mentioned something as to the payment, it will operate regardless, instead of 7 days. That's number one. Number two, if the parties did not expressly state something, but did they say something to exclude implied terms, like something like implied terms will not operate in our contract. If there is an exclusion to all implied terms or something, then that implied term as to trade will not operate. Now, if there is no exclusion as to implied terms, and this particular term has not been expressly stated as to how we should operate between the parties, then you now go to the second one. Is this term so well established, so notorious, that both parties know about the term or are presumed to know? It is when you have satisfied these two requirements, then the court will imply, or custom would imply the term into the contract. Do you understand that? Let's look at the case of London Export Corporation versus Jubilee Coffee Roasting Company. London Export Corporation versus Jubilee Coffee Roasting Company. Lord Jenkins said that an alleged custom can be incorporated into a contract only if there is nothing in the express or necessarily implied term of the contract to prevent such inclusion. Can you see that? And further, a custom will only be imported into a contract where it can be so imported consistently with the tenor of the document. Now, Lord Jenkins added a third requirement, which people do not really argue, but I just want to point it out for you. You know that our first requirement, that particular term, has it been stated in the contract? If the term has been stated in the contract, then you cannot imply anything otherwise. That's number one. Number two, has implied term be excluded by the contract? Do you understand? Did they say that, implied term as to trade, all implied terms as to trade would not apply in our contract? Once it has been excluded, then the parties wanted that they wanted to that their express term should be their express term. Don't imply anything to our contract. Express term is express term, right? Good. Number three, is the implied term such that it is well established and notorious that both parties know of it or are presumed to know? Right? Then what Lord Jenkins is saying, if you read that last part, is that when we are importing the implied term into the contract, is it such that it agrees with the tenor of the document as a whole? Is it such that there is nothing in the document that is going to contradict the implied term? Do you understand? Like, it agrees with the tenor of the document. So if we are able to look at these four things, whether or not they expressly stated what the term they want to apply is, whether or not they excluded the applicability of implied terms by trade, whether or not the term is so well established and notorious, and whether or not that term is consistent with the tenor of the documents. So those are the four things that you look at when you are talking about implied terms. Are you listening to me? And we are getting that from where? We are getting that from the, Lord Jenkins in London Export Corporation versus Jubilee Coffee Roasting Company, and also the cases before that. But now let's move on to the case of I think this is French, so I permit my French, but this will definitely not sound correctly. Les affréteurs réunis société anonyme. Sorry about that. Versus Walford, because this French is terrible. So les, L-E-S, affréteurs, A-F-F-R-E-T-E-U-R-S, réunis, R-E-U-N-I-S, société, S-O-C-I-E-T-E, anonyme, A-N-O-N-Y-M-E, versus Walford. Now what happened in this case? Walford, who is a broker, negotiated a charter party. I already told you in my previous set of videos what's a charter party. When you have a ship and somebody wants to rent your ship, it is called a charter party agreement. When you have a land and somebody wants to rent your house, it's called a land agreement, a lease agreement, or a rent agreement. Do you understand? So when we are talking about that of ships, then it's called what? A charter party. Now, Walford, a broker rather, negotiated a charter party between his clients, the ship owners. So his clients themselves are the ship owners and the hirers. Now, his contract with the ship owners stipulated that he was to be paid a commission of 3% of the estimated gross amount of the hire on the signing of the contract of hire. After the signing, but before the hire paid for the charter, the ship was requisitioned by the government, which means that the ship was taken by the government. And so the higher fee was not paid. The owners therefore denied liability to Walford as for his 3% commission on the ground that under the custom of the trade, commission was only payable when the higher fee has been paid. Now, I want you to understand something. There are certain facts that we need to understand. We have a broker. Who is the broker? Walford. Now, Walford, you know who a broker is, right? It's just like a third party. When you're looking for house, it's like an agent, the person that connects the house looker. That is the person that is the tenant that is looking for house with the landlord. After you pay everything, you always pay agent and commission fee for the connection and all that. Good. So in this context, we are talking about a broker between the ship owners and the hirer on a charter party agreement. Now, he connected the both of them, and according to their agreement, listen to me, according to their agreement, what did the agreement say? In the third line of the fact, the agreement said that his contract with the ship owner stipulated that he was to be paid a commission of 3% of the estimated gross amount of the hire on the signing. Listen, on the signing of the contract of hire. He was to be paid his 3%. So far they have signed, both parties have signed. So far they have signed, he was to be paid his 3%. Now, after the signing, but before they could pay each other their fee, that since the hirer wants to hire the ship, it is, okay, when you want to rent a land, it is when you are paying your money for the house that the landlord removes the money. That's how it is now. That's how it always is. Then the landlord removes the money. Let's say the house that you are renting is 400,000 naira per year, and then 400,000 naira is the real rent, 450 agreement and commission, total package 450. Do you get? So it is when you are paying your 450 that the landlord takes his 400,000 naira and removes his 50k and gives. That's how the trade and the custom is. It is on the payment of the money that you then remove that of the brokers. But the broker had put it in his agreement. It is not on the payment of the money that you give me my money. It is on the signing of the contract. Are you seeing the difference? So now, when the government requisitioned the property, the government said that they are not going to pay that 3%. Why? Because money had not exchanged hands with the charter party and the IRS. The IRS had not paid the ship owners, right? The IRS had not paid the ship owners, from which they would have removed the money for the broker. But was that what the broker said in the agreement? The answer is no. What did the broker say upon signing? Have they signed? Yes. Whether or not they have paid, the payment is according to custom, that when you have paid, that's when you remove the money and give to the broker. But that I told you that there are 4 rules, when you are looking at trade by custom. The first thing, in relation to that term, has there been an expressly stated term of the contract in relation to that term that we are saying that we want to imply? Has there been an expressly stated term? Yes. What is the expressly stated term? Pay me after signing. What is the implied custom? We pay after the other parties have paid each other. But that custom would only come to play in the absence of an express term in relation to payment, when to pay. But there is an express term on when to pay. So since there is an express term on when to pay, every implied term cannot apply, especially when we are talking about when to pay. Do you understand? It is after we cannot find an express term on the issue, then we then go to the second one, which is, has there been a clause saying that, oh, all implied terms or implied terms as to trade will not apply? Oh, there is no clause as to that. Then we then go to the third one, where we are talking about whether or not the clause is such that it is so rigorous, it is so well established that both parties presume to know. They will then go to the fourth one. The fourth one, according to Lord Jenkins, if I'm right, is that where the clause agrees with the tenor of the document. Do you understand that? But in this case, he already fails the first one. What is our first one? Whether or not there has been an express term on the issue. And yes, there is an express term. Pay me immediately after signing. Don't imply. It's when there is no express term that we imply the implied term. Do you understand? Here there is an express term. What did the court say? In an action brought by Watford for the order of specific performance of the agreement, it was held by the House of Lords that he was entitled to the payment of the commission. The alleged custom could not prevail over the express term of the contract. The contract has already expressly stated, this is it. Pay me after signing. You cannot then imply custom to override an express term that says pay me after signing. Do you understand that? So with that, we go to our second case. Our second case for today's class, which is a Gottschalk versus Elder Dempster and Co. Gottschalk versus Elder Dempster and Co. Gottschalk is spelled, let me write it on the board so that everybody can get it. SCH rather, ALK versus Elder Dempster. Elder Dempster and Co. So we have Gottschalk versus Elder Dempster and Co. Now, under a contract for the carriage of goods by sea, the term of which was contained in a bill of lading, the defendant undertook to consign some packages from Liverpool to the plaintiffs in Lagos. Although the defendant safely delivered the packages in the custom shed on arrival, one of them was missing when the plaintiff finally took the delivery. The plaintiff sued the defendant for the loss. Although the plaintiff's liability under the bill of lading ceased as soon as the goods were discharged, the plaintiff sought to introduce and rely on the custom of the port, according to which the defendant's liability would have continued even after the discharge of the goods. Now, before we go on, what are we talking about here? The defendants, they are supposed to deliver the plaintiff's goods from Liverpool to Lagos, and then the defendant carried the goods and delivered it in Lagos, but some of the goods were defected after the delivery. Now, according to their own express agreement, the moment there has been delivery, any defect that comes up after the delivery or as a result of the delivery, the people who delivered will not be liable. That's what they expressly agreed amongst themselves. As far as I've carried it from Liverpool and I've carried it to your port and it lands at your port, anything that happens at your port, I will not personally be liable. That's the agreement, right? But now, when they got to the port, something happened to the goods, and then the plaintiff, the owner of the goods, now wants to rely on a custom of the ports that says that where goods are defected when they arrive, when they are defected, then the person who delivers it will be liable. That's a custom, but that custom can only operate where there is no express term in their contract taking away the liability from the other party. Do you understand? There is an express term that says that when it gets to the port, I will no longer be liable. There is a custom that says that when it gets to the port, I will be liable. Which one will override which one? The express term that says that I will not be liable will override the custom that says that I will be liable. Do you understand? So it still speaks to our first rule. On that subject matter that we are talking about, has there been term in our agreement, an express term in our agreement? The moment there is an express term in our agreement, then that of trade or custom cannot be implied into the contract. An implied term cannot be said to override an express term. Do you understand? What did the full court of Ghana say? The full court of Ghana held, affirming the decision of the divisional court, and that no evidence of custom can override the terms of written contract. I like that. No evidence of custom can override the terms of a written contract. Has it been expressly stated? The moment it has been, you cannot override it by that of custom. Now, you can also see the case of Leyland Nigerian Limited versus Dizengov. Leyland, Leyland, Nigeria Limited versus Dizengov, Dizengoff. And the case of Bank of Africa versus Poland. Bank of Africa versus Poland. Now, to continue with the notes, which is the last thing of Africa, Bank of North versus Poland. Now, to continue with the latter part of our notes, the last part of our notes before we end, what's time? 48 minutes. 46 minutes. Okay, so to continue with the last, how many people are there? 8. I want to know if there will be questions for today. Now, to continue with the last part of our notes, one of the areas of contract in which customs and usages have developed extensively is employment contract. This includes the rule that a person who employs has the power to terminate where there is no express term for the latter. Now, this is what we are saying. When we have an employment contract, you know all this, I won't do apprentice, or I won't do stylist on the road, I want to do sales girl. You know all those kind of employment contract that we don't have termination, we don't have, you must give 3 months notice. You know all those kind of things. You want to do sales girl, yeah, start on Monday. How much your price? 15,000. What you go do? Come clean shop, stand for shop, answer customer. You know all those kind of things. Now, what is the rule? One of the areas of contract is employment contract. This includes the rule that a person who employs has the power to terminate the employment where there is no express provision for such termination. So if there is no express provision in what we were saying when I was employing you, I can just come to shop one day and say, you know what, I'm tired, come and start going. Do you understand? Anybody who has the power to employ has the power to terminate. Do you understand? If you know that you don't want to give the employer that much power, include it in the contract that, you cannot terminate except, and all those kind of things. What's our authority for that? Oki versus Taylor. OKI versus Taylor. Tailor. Tailor. So you can see what I'm talking about, and then we go to the last thing for today's class. Again, it is now the rule that an employee paid on a monthly basis is entitled to 1 month's notice on termination, as has been stated by the case of Kayme, Cayme v versus Allen, Jones and Co. Cayme versus Allen, Allan, Jones, Jones and Co. Also see the case of Aharonyi versus University College Ibadan. Aharonyi is spelled Aharonye versus University College Ibadan. And that we are done with our class. Before we round up, let me just do a quick recap for us over again. And then when we started our class, we said that when we talk about implied terms by trade and custom, we are talking about what Pack B said in the case of Houghton versus Warren. So when you are writing an exam question, if it's an essay question, just download every information that I've given you in this video. Download it there. I'm very sure that you will get your very high mark. But if it is not an essay question, but it's a problem question, raise your issue. By the time you raise your issue as to whether or not a implied term will operate in whatever happens, then the first place you start from what Park B J said. Park B rather said in Houghton versus Warren, where he says that the parties could not envisage everything when they are entering into a contract, and then the court would have to imply some of the trade and customs into a contract. And then you go further to show us in the case of British Crane Hire Corporation versus Ipswich Plant Hire Limited, where the court implied into the contract that even though you had not signed it, but there is an implied term that is operating in favor of the plaintiff. There's an implied term that is operating in favor where you have not signed it. There is an implied term of custom. It is the custom that is not only rigorous but something that both parties are aware of as they are participants in that particular trade. And then we go to the third case of Lord Jenkins, in what Lord Jenkins said in London Export Corporation versus Jubilee Coffee Roasting. And then when we look at that, I gave you 4 rules to follow. 4 rules. The first rule is whether or not there has been an express term, whether or not there has been an express term that is on that subject matter which you want to bring the implied term to counter. Do you understand? If there has been an express term, that express term will always override any implied term by trade or custom. But if there is no express term, then we go to the second one. Has there been a term excluding implied term by trade that says that implied term by trade will not work or something like that? And then when you go to the third one, what is the third one? Whether that this thing is so rigorous, the custom is so rigorous that both parties are presumed to know. And what is our fourth one? Whether or not that term agrees with the tenor of the document. If we have those 4, then you have you can then talk about implied terms. Then we go to our next case of Les Affretteurs Réunis Société Anonyme versus Walford, where there was already an express term, and then he was trying to bring an implied term to override the express term. The court said no. And you also have the case of Gottschalk versus Elder Dempster and Co., where the court also held the same thing, where there is an express term, you can't bring an implied term. Limited versus Dizongov, and the case of Bank of North versus Poland. And we talked about the case of Oki versus Taylor, where the person who employs has the power to terminate. And we also talked about where you are paying on a monthly basis, then you must give 1 month notice of termination, as in the case of Cayman versus Allens and Jones, and also Aharome versus University College Ibadan. And that is where we will end our class for today. But before we end our class for today, I would like to give you 30 seconds in case you have any questions, so that I can answer your questions before I end our class for today. So, are there any questions for me to answer? Are there any questions? Okay, so if there are no questions for me to answer, then I guess that's going to be the end of our class for today. Thank you so much for watching to the end of the lecture for today. We are also going to talk about another implied term, which is implied term by statute. We are talking about implied term by statute, but that would be in our next class. We are talking about implied term by statute in our next class. And what are the 3 implied terms by statute we will be discussing in our next class? Number 1, implied condition as to title. Number 2, sale of description. And number 3, we'll be talking about fitness for purpose. Implied term as to statute, sale for description, and implied term for purpose. Those are 3 things we'll be talking about. That's the part 1 of implied term by statute. In our part 2 of implied term by statute, we'll be talking about merchantability and all that. But that's going to be in our part 2. So I'm going to see you in my next class, where I talk about implied term by statute part 1. See you in the next class.